ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಲ್ಲ, ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಬರೆಯೋದು, FIR ಬರೆಯೋದು ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಏನ್ ಮಾಡಲ್ಲ, ಅಲ್ಲೊಬ್ಬ ರೈಟರ್ ಇರ್ತಾರಲ್ಲ ಅವರೇ ಬರೆಯೋದು. ಫಾರ್ಮ್ಯಾಟ್ ಇರುತ್ತೆ, 498 ಈ ತರ ಇರಬೇಕು, 304 ಈ ತರ ಇರಬೇಕು. ಅದು ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿ
ಇದನ್ನ
ಅವ್ಯಾಚ ಶಬ್ದಗಳಿಂದ ಬೈದರು, ಅಲ್ಲೇ ಮಾಡಿದರು. ಇದಿಲ್ಲದೆ ಯಾವ ಕಂಪ್ಲೇಂಟ್, ಯಾವ ಚಾರ್ಜ್ ಶೀಟು ಇಲ್ಲ.
The Lordship may kindly see the interim order. That is
That's
my
final order.
That is
My order.
yes, Your Lordship's order.
ಕಂಪ್ಲೇಂಟ್ ಸರ್ವ್ ಆಗಿಲ್ವಾ?
Again, they served unrepresented.
ರೋಹಿತ್ ನಾರಾ.
Yes, and now they've initiated arbitration. They've made a claim in the arbitration for money. Pure contractual dispute.
ಗಮೆಂಟ್ ಏನ್ ವಾಟ್ಸ್ಆಪ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
earlier order.
And incidentally, the FIR is in English. First time after a long time.
FIR is in English.
English.
ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ is in English.
Illa. Please come to page 48. Whatever is in the complaint, page 48.
ಯಾವ್ದೋ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬರ್ದಂಗಿದೆ ಕಾಗ್ನಿಸೆನ್ಸ್. ಏನ್ ಪಬ್ಲಿಕ್ ನ್ಯೂಸೆನ್ಸ್, ಕ್ರಿಮಿನಲ್ ಇಂಟಿಮಿಡೇಷನ್, ಕ್ರಿಮಿನಲ್ ಬ್ರೀಚ್ ಆಫ್ ಟ್ರಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ, ಹಾಕಿದ್ದಾರೆ.
ಅದು ಕಾಂಪಿಟಿಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ abuse of dominant position under the competition.
ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ, ಹಾಕಿದ್ದಾರೆ. ಇಲ್ದೇ ನಿಮ್ ರೈಟರ್ಗೆ ಇದೆಲ್ಲ ಎಲ್ಲಿ ಬರುತ್ತೆ? ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ, ಪ್ರಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಲ್ಲ, ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಬರೆಯೋದು, FIR ಬರೆಯೋದು ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಏನ್ ಮಾಡಲ್ಲ, ಅಲ್ಲೊಬ್ಬ ರೈಟರ್ ಇರ್ತಾರಲ್ಲ ಅವರೇ ಬರೆಯೋದು. ಫಾರ್ಮ್ಯಾಟ್ ಇರುತ್ತೆ, 498 ಈ ತರ ಇರಬೇಕು, 304 ಈ ತರ ಇರಬೇಕು. ಅದು ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿ
ಇದನ್ನ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್
ಬೈದರು. ಆಮೇಲೆ ಅವ್ಯಾಚ ಶಬ್ದಗಳಿಂದ ಬೈದರು, ಅಲ್ಲೇ ಮಾಡಿದರು. ಇದಿಲ್ಲದೆ ಯಾವ ಕಂಪ್ಲೇಂಟ್, ಯಾವ ಚಾರ್ಜ್ ಶೀಟು ಇಲ್ಲ.
ಕೊಟ್ಟಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನು
ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಸ್, ನಿಮ್ ರೈಟರ್ಗೆ ಹೇಳ್ಬೇಕು ಇಷ್ಟೊಂದು ಸ್ಮಾರ್ಟ್ ಆಗ್ಬಾರ್ದು.
ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿರ್ಬೇಕು.
ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ಬೇಕು, ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ನಾವು ಕೊಡ್ತೀವಿ.
ಕೊಟ್ರೆ ನೋಡ್ಬೋದು.
ಅದು ಮಾಡ್ತಾ ಇರ್ಬೇಕು, ಅದು ಕಾಪಿ ಪೇಸ್ಟ್. ಹಿಂಗಾಗತ್ತೆ. ನೀವು ಬಿ ರಿಪೋರ್ಟ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ, ಇವ್ರು ಬಿ ರಿಪೋರ್ಟ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್ ಇನ್ ಕನ್ನಡ accepting the or rejecting the bid report.
That's true.
Yes, we'll close this. ಸರ್ವ್ ಆಗಿದೆ. ಯಾವತ್ತಾಗಿದೆ? ಲಾಂಗ್ ago 24 ಆಗಿದೆ. ಎರಡು ಮ್ಯಾಟರ್.
Both are same. The number of accused is split.
Yes. There is anything? Ashirwad pipes. Yes. The ಇನ್ನೊಂದು ಯಾವುದು ಆನ್ಸರ್?
67.1. That is filed with the other.
Different accused.
Different accused.
Complaint is the same.
Complaint same complaint. They were same crime.
The subject petitions call in question a solitary crime in crime number 641 of 2024. The accused are different. The complainant remains the same. Therefore, the two are taken up together and considered by this common order. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner along with Sushal Tiwari, and the learned additional SPP B.N. Jagdish representing the state. The complainant, though served in the month of December 2024, has remained unrepresented even today. Therefore, the learned senior counsel for the petitioner and the state are heard. The second respondent is the complainant. The complainant and the petitioners have a transaction or a product supply agreement entered into between the two on 24/9/2022. Towards the product supply agreement, an advance payment was made of 50% of the purchase order for supply of 30,000 plumber Mitrana,
That's product name.
a product. A product, plumber Mitra, a product prior to entering into the product supply agreement. The second respondent had supplied some, it is alleged that the second respondent had supplied from some non-conforming products which were rejected by the company and sent back to the respondent. The dispute between the two thus gets generated on payment of money or short supply or wrong supply or otherwise. The parties in terms of the supply agreement were before the arbitrator. After claiming before the arbitrator, filing an arbitration,
Section 9 was filed.
after filing an application under Section 9, the complaint comes to be registered before the jurisdictional police, which becomes a crime in crime number 641 of 2024. This court, owing to the submissions made on 23/10/2024, had passed the following order. The interim order is in subsistence even today. The learned senior counsel submits that the parties, the crime so registered against these petitioners by the complainant arises out of a contractual dispute. And if it is a contractual dispute, the criminal law could not have been set into motion on breach of contract, notwithstanding the fact that the complainant himself is before the arbitrator, or the claims are now made before the arbitrator. In that light, the learned senior counsel submits that further proceedings, if further investigation, if permitted to continue, would become an abuse of the process of the law. The learned HCGP, learned additional SPP representing the state, would submit that though in the first blush it looks like a contractual dispute, the investigation in the case at hand is imperative, as the complaint so registered does make out cognizable offences against these petitioners and would seek dismissal of the petition. I have given my anxious consideration to the submissions made by the respective learned so and so, and have perused the material on record. The aforenarrated facts, though not in dispute, would require a skeletal reiteration. The agreement between the two, i.e. the petitioners and the second respondent, petitioner company and the second respondent company, happens on 24/9/2022. It is a product supply agreement.
98.
Arbitration clause ali. The product supply agreement
105.
has within it a dispute resolution mechanism. The dispute resolution is by way of arbitration under the Arbitration Conciliation Act 1996. The clause reads as follows, page 105. The dispute between the two arose on account of wrong supply or otherwise, and payment to be made by the petitioner, or by the payment to be made by the petitioners to the complainant, or the other way around. The parties, the complainant files an application under Section 9 of the Arbitration Conciliation Act. During the pendency of those proceedings, a complaint comes to be registered, which becomes a crime in crime number 641 of 2024. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint so registered, page 39 to 43. The gist of the entire complaint is reproduced by the police while registering the crime as gist of the complaint in column 10 of the FIR. Be that as it may, a perusal at the complaint would clearly indicate that a contractual dispute is blown to become a crime by become a crime for offences punishable under 429.
506, 284.
For offences punishable under 284, 268, 420, and 149 of the IPC. The said crime so registered on the face of it would is an abuse of the process of the law, as contractual disputes cannot be given a cloak of criminality, and the criminal law cannot be set into motion on on the said breach of contract, breach of